Welcome back. Hound under control. All right, so assault, protecting our rights to mental tranquility, trying to prevent batteries, really, prevent threats, um, and again, to try and keep the peace. There are some specific rules around conditional threats, whereby people put a condition on the threat and then try and argue that it's it wasn't an assault because there was a condition, a precondition that had to be met. And the law would fix that by saying, well, you can't put an unlawful request as a threat. You're not allowed to threaten, put an unlawful request to prevent it being an assault. So, your money or your life, Dick Turpin, you couldn't argue that that's a conditional threat and that the precondition undoes it because you have no right to offer to murder someone. So they have no real response other than to give you your money. So there's some old cases on that around Tuberville and Savage was the case where there was a thing called a seize time where you had to not pull out your weapons. You weren't allowed to use your swords, a seize. And a man put his hand on his sword, which is the assault gesture, like, grabbing your gun in your holster. And he said, if it wasn't for a seize time, I would run you through. All right. And that wasn't, it was held not to be an assault because the condition undid it. Okay. Now that goes back to reasonable apprehension of imminent contact because they can't complain that they reasonably apprehended they were going to be run through by the sword because he said, I'm not going to run you through with my sword. Even though he put his hand on his sword, which otherwise would have been an assault, wouldn't it? Because someone putting their hand on their gun is an imminent contact there and it's reasonable apprehension. But the fact that he said, if it wasn't for a seize time, I would kill you, I would run you through, that condition undoes the threat. All right? But again, you can't make preconditions. Give me all your textbooks or I'll punch you in the head. You're not allowed to use the unlawful condition of give me all your books to undo the threat. The threat is still alive, isn't it? So, really interesting talk. Reasonable apprehension, imminent contact. Recently had a case here where a guy wouldn't let a woman out of a cab and she kept saying, let me out, let me out. I want to get out. And he refused to let her out and said, I'm going to take you to my mate's. He's going to fix you up. And then drove her for a while to that address. And it was held that that was an assault for the duration of, it was also a false imprisonment. We'll get to that final third trespass to the person tort in a second. But the assault element is interesting because it tells us the minute the guy says, my mate will fix you up, that was enough to illuminate reasonable apprehension of imminent physical contact. And she was assaulted the whole duration, or the assault was alive for the whole duration of the rest of that cab ride. While we're talking about assault, it's noteworthy that the criminal jurisdiction uses the word assault for the threat and the punch, the battery as well, and has a slightly different use of the word assault. So criminal assault is different to a tortious assault, just to bear in mind. Okay, so we've had a battery, a punch or a touch, or any contact, bodily contact, direct and intentional, without consent, battery. We've got the assault, the raising of reasonable apprehension of imminent physical contact, an assault. The third tort we'll think about is the tort of false imprisonment. This is a beauty because this one protects our right to freedom of movement, our right to go where we want to, comma, unless lawfully constrained, unless there's a lawful reason. So again, a positive and a voluntary act that totally restrains the movement of the person, comma, without lawful consent. So a policeman saying, come with me, that is a false imprisonment, but there's lawful authority to detain you. A very old case, Bird and Jones across the River Thames, ye olde grandfather Thames, when bridges used to have buildings on them, that old. Anyway, a market stall holder put up a market stand on a footpath on one side, and someone tried to get past, and he said, move your market stall. And the guy said, no, just walk round. So he tried to sue him for a false imprisonment, and it was held, well, no, you weren't falsely imprisoned. You could have just gone round. And that gave rise to the element of total restraint. Now, this is an interesting tort. This, again, protects your underlying rights in freedom of movement. I like this tort because it's so strong, it's so powerful. These rights are so inviolable that you don't even need to know you've been falsely imprisoned. If your security guard or cleaner locked the office floor while you were working one night, you're falsely imprisoned. You don't even have to know about it. Isn't that amazing? Likewise, you don't even have to be physically restrained. So there was a case, Soames and Mahone, where a policeman said, come with me, we're going to Adelaide. This is from Melbourne, 8-hour train drive. He said, there's a identity parade. I want you to attend it. You need to come with me. And the guy felt so obliged to go with the policeman that it was held he was psychologically totally restrained. In that reason, he had no alternative. So he had to get on that train for 8 hours and go all the way to Adelaide, and turned out it was a hoo-ha and nothing doing. So he sued for false imprisonment for the duration of the train ride. And of course, the defence was, nonsense. He could have got off the station. He could have come back. He could have refused. But it was held, no, he was psychologically subsumed his will, was the wording the judge used, to the police officer, and as such was totally restrained. Interesting, huh? So you can be totally falsely imprisoned. You don't even have to know about it. You don't have to be in a cage. I could tell you I've locked the office doors and they're not even locked. And if you think they are, you've been falsely imprisoned. So it's a beautiful tort. It really protects that underlying right of, no, freedom of movement. Everyone should have the right to go where they want to go. All right, comma, unless there's a lawful restraint or a lawful authority for that restraint. So it's beautiful, isn't it? I really hope you can sense the civil liberties that underpin or that are born through these torts. Trespass to the person, assault, battery, false imprisonment, all protecting underlying rights of our bodily integrity, our mental tranquility, and now our freedom to move. So they're beautiful, aren't they? All right, that's the 3 trespasses to the person torts. Don't confuse assault with a criminal assault. This is technically a separate thing, but now we understand it's any apprehension of imminent physical contact. It needs to be imminent. It's another element of that tort. So if I ring you up and I'm in New York and I say, I'm going to punch you, that can't be an assault because you know I'm 10 hours away. All right, so it needs to be imminent. And that was the test in that case on taxi, Zanka, where I'll fix you up, my mate will fix you up later. Even though that was an unspecified duration of time, the court held that that was enough to be an imminent threat of physical contact. And rightly so. Who wouldn't be petrified in the back of that locked car being driven somewhere? Okay, and then false imprisonment, protecting our rights, freedom of movement. Again, there's restraint of trade. There's public policy there, isn't there? Why we don't want to restrict people. It's not right to be under arrest unless there's a lawful reason to arrest you, to stop you. It's not right. So the default is everyone can go wherever they like. Now, there's limitations, obviously, private land, etc. But beyond that, without lawful excuse or lawful authority, no one can restrain you or totally restrain you. Okay, so 3 torts to the person. Trespass to the person, 3 specific torts. In the interest of time, we won't go through it in the same level of detail, but trespass to goods is the same idea of a positive and a voluntary act that interferes with someone's exclusive possession or possession of the goods. And that's interesting, that's useful, because there's an old saying, isn't there? Possession is 9/10 of the law. And there's a reason for that, is because if you've got the goods, well, you have the enjoyment of them. So you have got a title in terms of a possessory interest over the goods. So to do an act contrary to the rightful owner's interests of the goods is a trespass. Now, that doesn't cover all aspects of property ownership. So another tort was born called conversion, and that's where I might have possession of goods that I don't own. Think of a rent-a-car. I've got the car, but I don't own the car. So I'm in possession of the goods, but I don't have ownership, but I do have possession. And if I do an act contrary or repugnant, is the word the law uses, to the owner's rights over those goods, then I would have deemed to have converted the goods. So if I cut a hole in the roof of the rental car while I've got it, I've converted the goods. All right, I haven't really interfered with the title. I haven't really trespassed, but I have converted them in that I've done an act repugnant. Likewise, if I lease it and then sublease it, that might be a repugnant to the head lease. They might say, well, no, you've converted those. There's a very famous case, Penfolds Wines, that deals with that very fact, where you have a bailor and a bailee who's got the goods on a bailment agreement. It's like a fixed term license. And then they do an act repugnant to the bailment agreement. Whilst they've got the goods, they started filling them with the competitors' wines. This was back in the day where you'd give the bottle out on consignment, like old milk bottles back in the 70s and 80s. And they did an act repugnant to the bailment, and that illuminated a right to immediate possession, and you needed right of immediate possession to sue in the tort of conversion. So the issue was whether filling the wine bottles with a competitor's product, non-Penfolds wine, was that enough to convert the goods, the bottles, if you like. And it was held, yes, that is an act repugnant to the interests over those bottles that the owner retained, even though they were out on a bailment arrangement. And it illuminated a right to immediate possession, and that gave title or standing to sue for the tort of conversion. So it's a bit technical, but that's it in an overview. Converting the goods with an act repugnant or contrary to the owner's rights or interests over the goods. So that's trespass to goods. Likewise, we have trespass to land, which again is a positive and a voluntary act that interferes with the exclusive possession of the land. And trespass to land, the merest a foot over the boundary, leaning over a fence in the airspace above the land, it just obviously then begs the question, what is land? You buy some real estate, how much do you own? How deep underground? How high in the sky? Does a British Airways plane flying overhead, is that trespassing your land? Because your airspace, well, the courts have found reasonable use or enjoyment of your land. So if you put a crane on it, then yeah, you can use all that sky, no problem. But you can't sue a plane flying overhead or a satellite that goes above your land. So it has a limit on reasonable usage of the height into the sky. And different jurisdictions have rules on how deep, because they want the minerals underneath. But on the whole, if you find gold on your land, then that's yours. But some governments have taken national ownership of subsoil, subground interests. All right, so trespass to land, similar idea, basically an act that interferes with your rights over land. Okay, now that was limited, so another tort was born to look after interests in land, and that's the tort of nuisance. So that could be a dog barking next door. So that's trying to protect your right to peaceful enjoyment of your land. And how can you sit in your deck chair on a sunny day having a barbecue with next door's dog barking constantly, or they've got bees and the bees fly over your land? It's not quite a trespass, but because there's no direct positive voluntary act, is there, by the beehive owner? But the bees themselves, or a smell or smoke if they're burning plastic and that's wafting over your fence, that's a nuisance. The tort of nuisance, because that interferes with your peaceful enjoyment of your land, regardless of, and you can sue there whether you're a landowner or just a tenant, as long as you've got an interest over the land. So the tort of nuisance is useful for noxious smells. It's been found. Done a Chaka case about mushroom farming. Apparently mushroom farming can generate horrific smells, far beyond what's reasonable. It was held, a very famous case, what is a nuisance in Chelsea might not be a nuisance in Bermondsey. So context is important as well. You know, back in the day when milk bottles again were delivered by horse and cart, then what about all the horses and the smell of manure in a CBD? When does that become a nuisance? But if you move to the country and bought an estate, then you shouldn't really be able to complain about the smell of cow pats next door because you're in the country. So you have to, that starting point, and this is nice, with these torts of nuisance, is live and let live. Isn't that beautiful? So the law has a bit of mutual tolerance as a starting point, but then beyond that, what becomes unreasonable interference with your peaceful enjoyment over that land or of your land, well, that may give rise to the tort of nuisance. And again, you could sue for abatement. You want it to stop. You get damages to punish someone. And if you can't use your summer home, your Airbnb, because of the wasps or the burning plastics, you might be able to get compensation for that loss. So, got person, trespass to the person, trespass to goods and conversion, trespass to land and nuisance. So that's a good overview of the torts that protect inherent rights or rights given to individuals, property, and land, or rights in and over land, like a tenancy or maybe even a mere licensee, some of this stuff. All right, owner of the goods and the person in possession of the goods. Mental tranquility, bodily integrity, freedom of movement. So that's a great overview of the underlying interests that torts law can come to the aid of, and via the law of torts give a private remedy where you're not in contract, you're not limited by the strict rules of equity, which are coming with clean hands. You can't have done any wrong to claim equitable relief, and also equitable relief can only be used as a shield, not as a sword. You've got no positive rights under equity. So they're useful to know. That's a good bedrock now of tortious understanding. Now we can take that and explore in detail probably the king of the torts, which is negligence. And negligence is beautiful and amazing because it protects all of our, all of us in society. As I said before, think of it like a jellyfish. It's interwoven in every act and action, whether you're riding a bicycle or having brain surgery. And there's a certain beauty to it. Now, it was famously Donahue and Stevenson, 1934, Snail in a Bottle, very famous, up in Paisley, a little cafe. And there'd been a build-up of cases prior to that whereby someone was harmed due to someone's failure to take reasonable care, yet there was issues around contract and privity. So a very famous case where a man bought a gun for his son, and he said at the shop, "Is this a good gun?" And the seller said, "Oh yeah, it's a great gun." Turns out it wasn't a great gun. Dad gave it to his son. Son goes, shoots the gun. It misfires and blows off his hand. Disaster, right? But could the son get any damages? The gun seller's in the wrong, clearly. He lied about the quality of it and the brand, and it was a knockoff. Obviously, privity of contract. Did the son buy the gun? No, the father did. And the father didn't suffer the damage. So strict rules of contract, positivist rules around privity, the doctrine of privity, that if you're not a party to the contract, you can't sue under it or be sued. Because of that, the son's left without a remedy. So you can see in years, hundreds of years leading up to Donahue and Stevenson, the court's frustration around not being able to compensate people who've suffered harm due to no fault of their own, and where there is someone at fault, and they should pay, because otherwise the loss lies where it falls, and that seems unjust. And it shifts the loss, doesn't it? Someone else. So the family then have to shoulder that economic impost of the handless son, or whatever that may be. Okay, Heaven and Pender, another case where people in a dry dock up on ropes painting a ship, and the ropes were tied negligently or were old and frayed, and the scaffold fell off and people got injured. Again, prior to negligence law, they were left remediless. Yet it wasn't their fault. All these men broken and battered on the floor, fell a bit significant distance. So the courts bent over backwards and tried to find some license. Oh, well, they were on the premises and reasonable occupiers' liability, and sort of fudged it a bit, tried to give them relief. So you can see in the build-up to the cases prior to Donahue and Stevenson, the court attempting to find a solution to fill this gap whereby, you didn't have a contractual relationship, you can't sue, but you're harmed, you're damaged, you've suffered loss through no fault of your own, and someone else is at fault who probably shouldn't have been doing what they did. So it's lovely because we're moving into the world of ought, O-U-G-H-T, what you ought to do. Acts, positive acts that harm someone else, but also omissions, failure to act, where someone reasonable would do that act. So you could be liable for an act or an omission. So back up to 1934, Donahue and Stevenson, in the lemonade shop, she orders a lemonade float, like a Coke Spider with lemo, and her friend pays for it with ginger beer instead of lemonade. And her friend says, no, I'll buy it. And she says, oh, let me buy it. No, I'll get this one. And because her friend paid, when she then went and got injured, there was a decomposed snail in the bottle. She poured it out. The ginger beer bottle was opaque. That's kind of key. We'll see in a minute, because there's no reasonable way of protecting yourself. She couldn't have seen the rotting snail. She was helpless. She totally relied on the manufacturer to manufacture that ginger beer in a way that wouldn't hurt her or kill her or injure her. And that's reasonable, isn't it, when you buy a product or a service? And had she handed over the money and won that little generosity battle at the till that we've all seen a million times, had she paid, she would have had rights under contract and could have had a remedy. End of story. But no, by virtue of her not paying, she was left remediless. She got horrific gastroenteritis and then nervous shock, yada yada. Big damage, but couldn't sue Stevenson, the manufacturer of the ginger beer, because of this doctrine of privity rule around contract and by virtue of her friend's pushy generosity that got her to the till before she got her hand in her purse. How arbitrary is that? So it went all the way to the House of Lords in London. It was a Scottish case initially. And it was a very famous judgment by Lord Atkin that said, it seems to me that, when that it's a bit like what's called the neighbour principle, that one should take care for the neighbour. Well, who then in law is your neighbour? Well, it's the very person that you ought to have in contemplation when you're turning your mind to the acts or omissions that then give rise to the harm. All right? So it is love thy neighbour, incorporated, enshrined in a tortious doctrine of negligence that now runs thus. If it's reasonably foreseeable that failure to take reasonable care could cause harm to the plaintiff or a class of persons to which the plaintiff belongs, then you are negligent for not taking that care. And you're liable in damages for the loss you cause. So it's a big tort, right? And there's lots of layers to it. And there's rules at every turn. But essentially, we want a duty. The first step is to find that someone owed you a duty to take reasonable care. All right? That's everywhere. That's at large. You take your car down to get new tyres. They owe you a duty to take reasonable care. There's two categories. There's settled law, where it's fixed law that there is a duty alive. Think school teacher, school boy. Think doctor, patient. It's settled law. We know that you need to take reasonable care for your acts or omissions in that situation. Your accountant owes you a duty of care. It's settled. And then there's novel cases where, like Mrs. Donahue getting ginger beer with a decomposing snail in it, or I think road users, certainly in Australia, that's a fixed duty. Road users owe other road users a duty to take reasonable care. Let's just deal with that. Let's just set a floor, a minimum standard, and we know we can deal with duty and move on to the next stage. So, duty to take reasonable care. How do you establish a duty? With a reasonable foreseeability test. Is it reasonably foreseeable that failure to take reasonable care could result in harm? And if the answer to that is positive, well, then a duty of care is alive. That's it. So it's a very low threshold. Now Australia, certainly in Victoria, they've legislated to try and get rid of obvious risks. And basically anything that's not far-fetched and fanciful will be reasonably foreseeable. So these are words that have been used in cases. If a risk is far-fetched and fanciful, well, then maybe you don't owe a duty for that. But anything else is reasonably foreseeable, even if it's highly, 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 highly unlikely. If it's foreseeable, then a duty would arise. The next stage is breach. Did the acts or omissions of the defendant fail to meet a standard of care of someone in that defendant's situation? This is a beautiful test because this applies to a taxi driver and a brain surgeon. All right? And the test is, what would the ordinary, reasonable, careful, prudent brain surgeon or taxi driver have done? That's it. It's a lovely universal test. So you can adduce evidence about what the industry standard is, what should have happened. And if they failed to reach that standard of care, and the court sets an arbitrary objective standard of care of what the reasonable train driver would have done in those situations, in those circumstances, could be dark, could be wet, can't see. There's all little rules, if you're self-intoxicated, then that doesn't get taken into account because that's your problem. There's all rules, but what would the reasonable person in your position do? Prudent, so not risky, not pulling out in a junction where there's not much room because I can get away with it. Just the ordinary, reasonable, careful, prudent defendant in that situation. what would they have done? So they set a standard of care, and then they measure the defendant's actual acts or omissions against that standard of care. And if it doesn't reach it, it's called a breach. And you breached your standard of care, you breached your duty to take reasonable care, and you're on to the next stage of the tort, causation. Did the breach of the duty to take reasonable care cause the damage so claimed by the plaintiff? Simple test of but for the breach, the harm wouldn't have happened. Again, there's some rules around that, but that's okay. There's another check called remoteness, stage 4. Is the loss so remote from the breach that it's kind of wrong to compensate it? That's another check of reasonableness, but as long as the loss is, again, reasonably foreseeable from the breach, that's it. When you're looking at causation, one of the rules is around the chain of causation. Did the breach cause the actual final damage? And oftentimes there's multiple breaches. I could get hit by a car, they hit and run, I'm dazed and confused. I walk out on the road and I get hit by another car because I'm semi-conscious. They might have been speeding. I then get an ambulance and they're on their first day on the job and they negligent CPR and I get brain damage. Who caused which loss? The courts have to unpack, because to maybe sue the first hit and run for my ultimate brain damage through a negligent speeding and then a negligent CPR through a negligent paramedic, did that initial damage, breach of a duty to take care, cause my final loss? And the courts have a look at what caused what damage, and they're called novus actus interveniens, intervening acts, that essentially, the best way I can describe it is if you set a ball rolling down a hill, if something knocks it off its trajectory, then that's probably an intervening act. And the courts will then apportion liability for subsequent damage or loss to the tortfeasor of the intervening act and escape the original tortfeasor from subsequent liability beyond the novus actus interveniens. So when we look at causation, we look at, are there any intervening acts that break the chain of causation that would then reduce liability to the original tortfeasor? So duty to take reasonable care, breach of that duty, causation with no intervening acts, and remoteness. And finally, damage, in that damage is the gist of the action. In negligence law, in the tort of negligence, no damage, no action. You can't sue. And that's interesting and probably right. And that's because in the trespass torts that we've covered earlier, you don't need damage. The wrong to the right is the damage. That's why the merest touching can be a battery. You've wronged the right. That's the tort. Whereas not so in the tort of negligence. Damage is the gist of the action. All right? And then the plaintiff presents their damage and the court awards damages, which are compensatory usually. That's the whole point. Back to Posner, the American jurist. You're just economic shift rationalization model or view of torts. You shift the loss so it doesn't lie where it falls. You shift that back to the tortfeasor. They can pay for the damages, for the damage. Different heads of damages: pecuniary, non-pecuniary, future loss of work, past pain, suffering, compensatory, occasionally exemplary damages, where the conduct of the other party's been poor. They used to do punitive damages, where they'll really try and send a message to the industry. But obviously, big awards of damages are good, as we told our doctors, because it lifts standard. It lifts standard of care across the industry. So because someone gets the wrong injection into a spine and is a quadriplegic, and because of that litigation, all subsequent vials are then coloured a different colour, so that never happens again. That's a great thing, isn't it? That's so much more positive than this negligent damage occurring again and again and again. Have a look at a truck at the traffic lights with those little plastic toggle things on their bolts. That's some industry standard to prevent loose bolt affixing. So there's things we can put in place as a society to reduce overall harm, to reduce overall damage and loss, to make the world a better place. And the tort of negligence goes some way to doing that. In fact, all of the torts do, because they protect bodily integrity. They protect mental tranquility. They protect freedom of movement. They protect your interests over goods and land. They help. They are so important for universal remedy where you're not in a contractual relationship with someone. They don't owe you anything. They've not agreed to anything. Yet they do owe you, certainly with the tort of negligence, a duty to take reasonable care for your safety. And that can only be a beautiful thing. All right, so that's negligence law, the king of the torts, the youngest of all the torts, by far, yet by far the most litigated, known as the king of the torts. And as I said, in some jurisdictions, they've tried to stuff that genie back in the bottle due to rising insurance costs. That's debatable, but let's not do that now. One thing to note as well, in the US, the juries set the damages. That's why they're millions of dollars for a burnt tongue on a McDonald's coffee, whereas in the UK and in Australia, the judges set the damages. And there is a little yellow book, what's a leg worth, what's an arm worth, what's a stitch worth. And there are, as I say, statutory caps now on that to try and curtail damage awards amounts, which some critics say is totally unnecessary and goes to the very heart, contrary to what the tort of negligence is trying to do and achieve by redressing wrongs, putting people back in the position they would have been, making tortfeasors pay, the deterrence effect to the industry, best practice standards, industry standards, etc. So some argue there's no need to put that genie back in the bottle. Let it out. it was out for a reason. But others warn of the litigious nature of society, certainly in the US, and they don't want their courts plugged up. All right, that's negligence. I also mentioned defamation, and I think no overview of torts law would be complete without having a think about the underlying right that the tort of defamation is trying to look after your reputation in the eyes of right-thinking members of society. Now, what that is obviously up for grabs, but we've just had the Johnny Depp debacle of a suing and a counter-suing for defamation, of reducing or lowering their reputation in the eyes of right-thinking people. And Rebel Wilson had a case a few years back in Melbourne Supreme Court arguing she lost movie contracts due to defamatory statements in a news media outlet. And likewise, Johnny Depp claimed he lost future movie contract deals due to defamatory statements by his ex-partner, Amber Heard, again published in the media. So you're trying to protect your reputation. You've got to be quite wealthy to sue for defamation. These are not cheap matters to run. And oftentimes it's sports figures or personalities who feel that their portrayal in the media has been such that it's cost them financial windfalls down the track, so they'll sue for the defamatory conduct. Some people want a repudiation, an apology. Some people are just happy with a retraction. Other people want the money. It is important because there's the old saying, isn't there? It takes a lifetime to build a reputation. It can be lost in a second. So I think you're standing in society for making money, for business, but for not to be shunned socially. Is important, has a value. And I think that's why this tort still stands and is still litigated to this day, because on one level, all you've got is your reputation, isn't it? The rest comes and goes, and your ability to interact and be in the world and exist in the world and make money in the world and have a social time in the world depends somewhat on your reputation. So the tort of defamation will come to your aid if you feel you've been unfairly defamed and that it's cost you anything, or you just want an apology, you want it retracted. Bob Smith's not a pedophile. That was a false allegation, and he wants the record set straight, for example. Bob being a fictional example. Okay, so torts are everywhere. Tortious duties are everywhere. We owe tortious liability to people we don't know and we haven't met. We certainly haven't got agreements with people. But overall, it aims to keep the peace. It aims to give people a legal remedy for a wrong. And it aims to shift loss and provide economic relief to plaintiffs harmed through no real fault of their own. There are obviously some defences to these torts. Valenti non fit injuria is a defence for voluntary assumption of risk. If I go skydiving, I might have to sign something to say that there are inherent risks in jumping out of a plane and that I won't sue the owner for negligence. For damage caused other than their negligence, if they give me a holy parachute and not a religious type, then I might still be able to sue for that negligence. But the inherent risks of a dangerous sport, Formula One driving or spectator, the disclaimer outside a Grand Prix, is pretty serious. Injury or death, I think you waive rights to suing for when you enter a GP arena or stadium. So there's some defences. Probably the biggest defence in a negligence claim is contributory negligence, and that's where the defendant claims that the plaintiff has brought their own negligence to bear. So think about not wearing your own seatbelt, and then you have a crash. Well, obviously your damages are far more than they would have been had you had your seatbelt on. So it's not right that you can then sue because you went through the windscreen and all those horrific damages. So your damages award against the defendant tortfeasor who may have been negligent and caused the crash would be commensurately reduced by the amount that the court deems that you, as the plaintiff, contributed towards your own loss by the not wearing of your seatbelt. So, crossing the road when the red man's flashing and then you get hit, you're going to have your damages reduced because of your contributory negligence. Because on a funny way, you also caused that accident to happen, that harm to happen. Even though the other person might have been drunk and speeding and obviously negligent, you also contributed to that harm. So there are some defences for all of these torts that defendants can avail themselves to, but ultimately it's for the courts to decide and to shift those loss and those economic resources to better place all the parties moving forward. Obviously, the world of insurance has somewhat changed the playing field. However, there is some deterrent in that insurance premiums obviously go up if you're negligent and constantly paying out. But obviously insurance does skew the economic impact on a defendant if they're insured against that loss or risk. Still, notwithstanding, it does provide a huge redress for people harmed or injured, whether that's their reputation or physically or financially. There are economic torts, which can have a think. There's a case, Headley Baxtendale, negligent financial advice that leads to loss. Same sort of thing. What would the reasonable person have done? There's a test there of reasonable reliance. But if someone's holding themselves out to provide expert advice and they do so negligently, and there's pure economic loss, it's called, and that flows from a breach of a duty to take reasonable care, well, it's only right that that's compensatable. Likewise, there is now the tort of pure mental harm, where it's not consequential mental harm. If you hit me with a car and break my back, and I have physical injury, and then I get depressed and I get mental injury, that would be called consequential mental harm. Whereas you could just be negligent to me and the only loss I cause is psychological or mental harm, and that's called pure mental harm, and you can now sue for that, and rightly so. So if I'm attending the aftermath of an accident and I suffer PTSD, I may well be able to claim for damages off of the original tortfeasor, because their negligence has caused the train crash that I then am a first responder to, for example, and then I develop an injury. So that mental harm nowadays doesn't have to be consequential on physical harm. I don't have to break my leg on the scene to then bring a claim for pure mental harm. I can just do that in and of itself. So again, you can see that the negligence and all of the torts are trying to reduce harm in society. And for that reason, they're probably my favourite area of law. And I hope you've enjoyed today's whirlwind overview of the Law of Torts. Thanks very much.